NEPA is the failure to prepare an EIS. And the three basic questions here is it a major federal action? Talk about, does the action potentially have significant impacts on the human environment? And third, what are the scope of those impacts? Secondly, even if an EIS is prepared, is it adequate? Challenging the adequacy of an EIS that has been prepared by an agency. So some of the things that might be subjects of challenge is, has the project been defined properly? What is the project's purpose? How has that been defined? Have the impacts been analyzed properly? So that includes, all of the possible impacts, the method of analysis, and so forth. So there are issues here relating to tiering of impacts, of the analysis of impacts, looking at cumulative or synergistic impacts, supplemental analysis of impacts, the degree of specificity, dealing with predictable impacts versus merely speculative impacts, and the geographic scope, which, in terms of looking at, how far out you're analyzing the impacts. Alternatives that have alternatives been considered and analyzed, and has mitigation been considered and analyzed. One of the big things about NEPA is that it requires, in the impact analysis, a consideration of a reasonable range of alternatives to the agency's action. So you're analyzing the agency's action, but then comparing it to a reasonable range of alternatives, including the no action alternative. Including the no action alternative. But this is why the definition of project's purpose is so important, because very often the agency will say, well, if we took no action, obviously there would be no or few environmental impacts, but we could not achieve the purpose for which we are taking the action. Right? That tends to be the way the analysis goes. And you're like, well, that seems obvious, but they need to do it. They need to say it, right? Because part of the whole idea is to call attention to the public's attention to the fact that there are adverse impacts on the environment from the agency's action, and one alternative is simply not to take the action. But then what are the trade-offs involved in that? Well, obviously, you wouldn't achieve whatever the purpose of the project was. And then finally, there are procedural actions, the challenges to the agency's alleged failure to follow the proper procedures. That includes the timing of the analysis, the timing of engaging in the environmental impact assessment process. Is a draft EIS been made available to the public? Has the public had an opportunity to comment on the draft EIS? And then there's some other specific procedures that, that's sort of a placeholder just to let you know that you may have to look at some very specific kinds of procedures depending on what kind of action you have. So this is the basic language. 42 USC section 4332, that's section 102 of NEPA. And it says Congress authorizes and directs that to the fullest extent possible, all agencies of the federal government shall, okay, so non-discretionary duty, right, shall include in every recommendation or report on proposals for legislation or other major federal actions significantly affecting the quality of the human environment, a detailed statement by the responsible official on the environmental impact of the proposed action. So that's the language. And then there are what are called CEQ regulations. CEQ is the Council on Environmental Quality, and these regulations interpret NEPA, the terms of NEPA. They establish procedural requirements to satisfy NEPA, and they also impose some new substantive requirements consistent with the statute's purpose. That last part, as you might guess, could possibly be more questionable nowadays with the sort of question about the non-delegation doctrine. Has Congress delegated too much authority to the Council on Environmental Quality to create new law, in essence, as opposed to merely interpreting and implementing the statute? Who knows how that would go, but that's the gist. Okay, so one of the things that we're talking about is obviously when the government is going to actually act in a way that is going to have a significant impact on the environment, they're going to have to do an EIS. But when they are considering a proposal, either a proposal for legislation or a proposal for action, either to adopt a set of regulations, to adopt a set of action items that they're going to take. They're going to cut trees in the forest. They're going to build a road. They're going to manage the national park in some new way, so on and so forth. They have to engage in environmental impact analysis. Okay, so not just actions themselves, but proposals, recommendations for legislation, that sort of thing. When the statute says major federal actions significantly affecting the environment, the CEQ regulations say that major reinforces but does not have a meaning independent of significantly. So basically, a major federal action is one that significantly affects the human environment. This applies to new actions, but also continuing actions when a decision is made to continue that activity. And there are sort of four major categories: an adoption of official policy, adoption of formal plans, adoption of programs, and approval of specific projects. All of those are going to trigger the environmental impact assessment. Significant impacts on human environment. CEQ regulations say there are two factors to consider: context and intensity. Context meaning understanding the context, the environmental context in which the action is going to occur. And then intensity is the intensity of the action and its impacts on the environment. Okay? And if it's a sensitive context, or if it's a relatively significant intensity, either of those will trigger the requirement to do an EIS, because that will be considered significant impacts on the human environment. Okay? Cumulative actions have to be, cumulative impacts have to be considered. Okay, so when you're looking at cumulative impacts, but you also have to think about cumulative actions. Okay, so action A leads to action B, which leads to action C, and so on and so forth. And at what stage do you have to do an EIS? And so we're going to talk about that. We're going to look at some examples of that. The agency doing the environmental impact analysis. And that, by the way, each agency does their own. Okay, right? Each agency does their own, and they're looking at short and long-term effects. And they also have to look at unique and endangered resources. So I didn't get my act together. We actually have too much to do, but I was gonna play some Luis Fonsi before class, because to help you remember that one of the acronyms in NEPA law is FONSI, which is a finding of no significant impact. Okay, so that's one of the options instead of preparing an EIS. And so in which case can you do that? So let's look at the process. So we start with an idea out there. Might be from within the agency, it might be outside the agency. So there's an idea. Hey, we ought to cut these trees in the forest. We ought to build this road, right? We ought to approve this power plant in this neighborhood, right? There's any number of possible ideas. It is not until the idea becomes an actual proposal that NEPA kicks in. Okay, it's not until the idea becomes an actual proposal. So if this is just one of many things the agency wants to just sort of kick around and discuss without having a specific proposal to do something. So like we may say, hey, let's have a discussion next week about various kinds of road building projects. Or let's have a video conference with several different folks in the agency to talk about assessing and considering the environmental impacts of power plants on low-income neighborhoods of color, right? So they will say, hey, we ought to talk about that, we ought to kick these ideas around and so forth. That is not yet a proposal. Okay, is everybody seeing that? On the other hand, if you're at the point at which you say, okay, well, we're going to build this road, and now we've got to start thinking about awarding contracts for the building of this road, now you have already passed the point of the proposal, right? So the key is, when do you have a proposal? And in order to to move forward with the proposal, you have to make an initial decision. The agency that's going to be considering the proposed action is going to have to make an initial decision about whether this qualifies over on the right as a categorical exclusion. Okay, so the statute has a variety of categorical exclusions that apply. Some of them you might imagine deal with things like national security and so on and so forth, emergency responses, etc. So that's one possibility. It's a fairly limited list, and what your proposal has to clearly and squarely fall into the categorical exclusion before you can take advantage of it and say, hey, we don't have to prepare an EIS because this is categorically excluded from NEPA. Yep, so that's one possibility. Another possibility is just to go forward with the EIS. Right? You just say, hey, we know that building this entire, this proposal to build this entire interstate across 6 states, over how many ever acres of land and so forth, is a major federal action that's going to significantly affect the environment. So we can go straight to preparing an EIS. Okay? So if that's the case, you can just go ahead. If, on the other hand, there is some uncertainty about whether this is substantial enough in its impact on the environment, or substantial enough of a project to require an environmental impact statement to do the full study, then what happens is the agency prepares is called an environmental assessment, an EA, environmental assessment. So we have so we've got EIS, now we've got EA, and the EA is sort of an initial way of looking at the proposal to sort of lay out, okay, what might be the impacts? What is the project? What's going to be involved with the project, and what kinds of environmental impacts might it have? If the agency feels very confident that the project is not going to have any significant impact on the environment, they prepare a FONSI, a finding of no significant impact, okay? FONSI. And then if they do decide to do an EIS, then they proceed with the EIS. At whatever stage a decision is made, the agency also has to prepare what's called a ROD, a record of decision. ROD, and I know it's not up there, so you have to add it to your notes. ROD, record of decision. And that is basically a procedural requirement that allows people to track what decision was made, right? Does everybody see that? Okay, so that's something that gets published in the Federal Register. Actually, all this stuff gets published in the Federal Register, okay? So, but that way we know what decision was made. One of the things that can happen with the FONSI, and by the way, agencies love doing FONSIs, right? To find no significant impact. Why do they love to do that? Other than this, they want to play Despacito on their computers. No, why do they want to do that?
Is it easier?
Easier in what way?
Less time consuming?
Less time consuming, less
money?
You're right, less money, less consumption of agency resources, time, money, staff, attention, etc. You move forward with the action more quickly, right? Of course, agencies do not, the agencies have some competing incentives. But one set of incentives are all about avoiding the time and effort and work and so forth of an environmental impact statement. Has anybody ever reviewed an EIS or looked at one? Anybody? Yes? Okay, 2 of you. Okay. How long are they?
If you count all the tables and stuff, they're huge.
Massive. Just massive. Okay? This is very detailed descriptions of all possible environmental impacts, everything that the agency is going to do, what's all involved in it, what kinds of impacts that's going to have. And just think about it, right? There's pollution, and there's different kinds of pollution. There's different kinds of species that are going to be affected, different kinds of ecosystems that are going to be affected. There's going to be human communities that are affected, et cetera, et cetera. And there's going to be a lot of scientific data that's gathered. There's going to be modeling because you don't know for sure what the impacts are. You're going to have to predict them, right? And so, and various contingencies. Well, if we do this, but that happens, right? So what happens if we take this action and there are these various effects of climate change? So we can have one climate model that suggests this. Well, what happens if it's a different model of climate change? What if it's wetter? What if it's drier? Right? So all that kind of analysis has to go in it. What happens if there's a major hurricane? What happens if there's a major earthquake? Right? There's a variety of different kinds of things that go into this. What happens if the agency gets partway into the project and the funding dries up? Right? So like, are the environmental impacts of a interstate that's half completed different in any kind of way than the completed project? Does everybody see that? So that's those sorts of things might be significant. So having said that, agencies also know that if they don't do an EIS, they're going to be sued, right? If they don't do an EIS, they're going to be sued. So you get sometimes different kinds of judgments made within the agency about whether we really have to do one, or whether maybe it's safer to go ahead and do one, right? So that's a judgment call. But what they're looking for are ways that they can sort of minimize the risk of losing in litigation. Okay, and listen to what I said there: losing in litigation, not to minimize the risk of being sued. All sorts of people will sue the agency for all sorts of reasons, right? Okay, that doesn't necessarily mean the plaintiffs would have a winning claim. They might or might not. Okay, but do not ever ever tell your client, well, if you do this, you won't be sued. Okay? That you're just setting yourself up for a problem with your client when your client ends up being sued. Right? What you want to do is you want to say, oh, if you're sued, if you do this, and then you're sued, we have a very good chance of winning. Right? Does everybody see the difference in that? Because, I mean, the lawsuits, I mean, sometimes the lawsuits are just going to, I mean, sometimes the plaintiffs think they can win, and sometimes the lawsuits are there because it's a way of putting more pressure on your client and what they're trying to do and so forth. So don't tell them they're not going to get sued. But the agency says, hey, you know, we will be in a better position to defend ourselves if we do X, Y, and Z. Well, one possibility is what's called a mitigated FONSI. Okay, so let's assume this is the impacts of the original proposal, and this is the threshold of significance, and it crosses the threshold of significance, right? Okay, yes? But now the agency adopts some proposed mitigation measures that offset the impacts such that the net impacts are now below the threshold of significance. Right? And so agencies might want to choose to do that. They might want to say, we're going to move forward with this proposal. We're going to issue a FONSI, but it's going to be a mitigated FONSI, and our proposal will include in it this mitigation measure, this proposed mitigation measure that we will do. That, so it might be, for example, there might be some adverse impacts to wetlands, but you might offset them, and that might be significant, but if you do some restoration of some adjacent wetlands that have been degraded, now you can offset that, and the net impact is below the level of significance. Does that make sense to everybody? Okay. So that is what a mitigated FONSI is. Okay. So again, remember what we're trying to do with NEPA is to get agencies to take a hard look at the environmental impacts of their actions before they take the action. We want the agencies to publicly disclose the details of the proposed projects and actions and their likely environmental impacts, and that NEPA is a source or a center for the generation of litigation over this, but at the same time, NEPA is a set of procedural duties. It does not impose any substantive requirements to actually protect the environment. Instead, it is about acknowledging the environmental impacts, considering them when you're making your decision, considering the alternatives, and that sort of thing. Okay, so again, this is just a review of of the possible challenges. So let's start with the first kind of question, which is an EIS required? And to give you a feel for the kinds of questions that can get asked, there's this famous case, Cluffy versus Sierra Club, where the U.S. The federal government had a plan for coal leasing. Okay, some coal leases, leases of lands and to be mined for coal, and they developed. They had sort of a national program that they're going to have some standards and principles and policies and so forth in place for how lands get identified and leases get considered, proposals for leases get considered. Then they organized all this around regions, and so this shows you what the regions are: the Appalachian Basin, the Gulf Coast, which actually really isn't, none of that, as you can see, is not really on the Gulf Coast, but you get the idea. the western interior, the Illinois Basin, the Colorado Plateau, and the northern Rocky Mountains and Great Plains. Which, by the way, as you can imagine, there are grassland and prairie dog issues in here, right? Okay, so it's not a case about grasslands and prairie dogs, but just to call your attention to that. All right, and then, of course, they're going to make decisions on a lease-by-lease basis. And what happens is the Sierra Club sues over the regional programs, okay, so the regional programs. And they say these regional programs exist and no EIS was ever prepared. And they have to, in order to organize and implement this leasing program on a region-by-region basis, they have to actually prepare an EIS. And the court says, no, they don't. No, they don't, because there is no existing or proposed plan or program at the regional level. This is a way of taking a national policy, organizing it region by region, but the actual action is lease by lease, right? The actual action that the government takes is on a lease by lease basis. This is merely for administrative convenience to have this sort of regional organizing. Okay? So this is, again, just a reminder of the language, right? Every recommendation or report on proposals for legislation, well, that's not bad, or other major federal actions. So the question is, what's a major federal action? And the court says there is no action here. They point out that in the purpose section, NEPA's purpose is not to generate paperwork, even excellent paperwork, but to foster excellent action. So something that you can probably appreciate. Okay? The statute also says that the agency shall integrate the NEPA process with other planning at the earliest possible time to ensure that planning and decisions reflect environmental values to avoid delays later in the process and to head off potential conflicts. So the statute itself emphasizes early NEPA process, right? To consider environmental impacts early on, but it says in terms of timing, as close as possible to the time the agency is developing or is presented with a proposal, so that it can be included and so on and so forth in the decision making on the proposals. That's what it says. Okay, right? Okay, so do you see some tension there in the statute itself? As early as possible, but as close to the consideration of the proposal, right? Does everybody see that can be a tension there, right? Okay, so so you've got both language, but lo and behold, the statute also defines what proposal means. So proposal exists at that stage in the development of an action when an agency subject to the act has a goal and is actively preparing to make a decision on one or more alternative means of accomplishing that goal, and the effects can be meaningfully evaluated. Preparation of an environmental impact statement should be timed so that the final statement may be completed in time for the statement to be included in any recommendation or report in the proposal. A proposal may exist in fact as well as by the agency declaration that one exists. Okay, so basically the statute says just because the agency doesn't call it a proposal doesn't mean that it's not a proposal, right? Isn't that an invitation for the court to look at what the agency's actually doing and compare it to the definition? Okay, once again, the definition. Okay? Agency has a goal and is actively preparing to make a decision on one or more alternative means of accomplishing that goal, and the effects can be meaningfully evaluated. Okay, so one of the things I want to encourage you is, it's an environmental law. Tie yourself to this language. This is the statute. This is what it says. So when you're sort of saying, hey, does the agency have a proposal or not, come right back to that and apply that, okay? And obviously, it can be interpreted in any number of different ways, right? But the gist is, in Kleppe versus Sierra Club, is the organizing of these leases at a regional level is not a proposal for an agency action. There's no decision on one or more alternative means of accomplishing the goal. Instead, what they're saying, and they also said that effects can't be meaningfully evaluated. The effects can be meaningfully evaluated only on a lease-by-lease basis, when you know actually what's going to be leased and where it's going to be and what kind of impacts it's going to have. And that's the point at which the agency is considering an action that would implement its goals, right? Does that make sense to everybody? Okay, so that's what's going on in Kleppe versus Sierra Club. I'm going to skip through the next couple slides because they're just repeats of. So, standards of judicial review, obviously they're looking for is the agency complying with the statute, is the agency complying with CEQ regulations, and this is typical stuff, how much deference does the CEQ regulations get? We talked all about Chevron deference and so on and so forth, right? So basically substantial deference, okay? And this is very, just basically review, okay? So rule of reason is, this is a new thing here. So in the NEPA category, NEPA area, the courts will often use the term rule of reason when they apply the arbitrary and capricious standard, okay? That just, if you've been in law school long enough, you know that reasonable just gets thrown out there a lot, and obviously the court is making some decisions, some judgments about what's reasonable or not. But this is basically, we're going to defer to the agency's discretion if the exercise of the discretion is reasonable in light of NEPA and the CEQ regulations. Okay? Obviously, if it's not, then it's arbitrary and capricious and an abuse of the agency's discretion. I wouldn't get too caught up on the difference between arbitrary and capricious and an abuse of discretion. It appears to me, in all these cases, that the courts just kind of use that interchangeably. That's pretty loose and not very satisfactory, but it is what it is. The court gives some deference based on the agency's specialized expertise and competency, but the underlying statutory purpose, Congress's intent, is for the agencies to follow these procedural requirements. So the agency does not have any special expertise to decide to skip the procedures or to avoid doing the EIS altogether. Where you get deference based on the agency's specialized expertise or competency is where there may be disagreements about exactly what the impacts are. Okay, so if the agency scientists say the impacts are, A, B, and C, and the environmental group that's suing say the impacts are A, B, C, D, and E, well, the court might defer to the agency so long as the agency considered D and E and has some expertise-based, so in other words, scientifically based, evidence-based reason for rejecting D and E. Does that make sense to everybody? Okay. So that's the gist of the standard of judicial review. Coming back to the Kleppe versus Sierra Club case, we had the question about whether there was a federal proposal, and they said no. But they did say that a single comprehensive EIS could be required when several proposed actions are pending at the same time that will have cumulative or synergistic impacts in the region. So if there are a dozen leases, they're all being considered around the same time and taken together, they would have cumulative, that's additive, right? Impacts, let's say you just put a number on them. Let's say lease number 1 is going to have an impact of 17. Lease number 2 is going to have an impact of 13. And then lease number 3 is going to have an impact of 4. And so on and so forth. When you add it all up, that's cumulative. Synergistic impact is how they intersect or with each other. So synergistic is, you add two things together and it's bigger than just the addition of the two because they interact with each other, right? So, you know this like from just like elementary school science. You put one thing in, and you put the other thing in, and it explodes and it or bubbles or it does something. It's something more than just the two things together, right? Right, so that's synergistic impact. And so both cumulative and synergistic impacts will have to be considered. And why? Why? Because think about this. Let's assume that that coal mining company wants to get a dozen different leases from the federal government in Wyoming. All in the same general area, but each is in a somewhat different place, okay? And they're all going to get them around the same time. But they're sort of close together, but you see why it's in the interest of the mining company, and perhaps in the interest of the federal agency, to treat those as 12 totally separate proposals, none of which by itself is going to have a significant impact on the human environment. So we see why that would save a lot of time and effort, right? If you just have 12 different decisions, and all of them have fancies, right? So we see that? Okay. But, it's the same company, it's the same coal mining, it's all in the same region. They're all going to be really, in essence, having either cumulative and/or synergistic impacts together. Okay, so then the agency, in that case, would have to consider them together in one EIS. So who gets to make that decision? So Kleppe versus Sierra Club, the court says, in this case, U.S. Department of Interior determined that the environmental impacts were not sufficiently related to consider together, and the court defers to the agency's specialized competency or special expertise on this. And they say, okay, the agency is the one that's best able to determine whether these coal leases are sufficiently related or not. Okay? Now, having said that, I said determined. Okay, and I emphasize that word. What does that mean? It means the agency actually gave a lot of attention to whether they were related or not, looked at the evidence, included the evidence in their decision, and made a reasoned argument or had reasoning in the decision to support their determination that they are not related. Does everybody see that? Okay, that is very different than just a conclusory assertion. Okay? So conclusory assertions do not do well under APA or NEPA. Right? Does everybody start seeing that pattern? The agency makes a conclusory determination. Doesn't refer to the relevant factors, doesn't refer to evidence, doesn't look like it's made a careful, reasoned decision, then the court's not going to defer to the agency. They're going to say this is arbitrary and capricious. In this case, there was an actual reason-supported determination. We might, I mean, obviously the Sierra Club disagreed with it, right? Different, reasonable minds differed and disagreed, but nonetheless, the court says, well, this is the agency's expertise, special competence. So I was talking about cumulative impacts. This is a basic definition about incremental impact of the action, past, present, reasonably foreseeable future action, whether federal or not. Okay, so that's the CEQ regulations on cumulative impacts. There are CEQ regulations on connected actions. Okay, so that's another thing. Are the actions connected to each other? This is, you have to consider connected actions in a single EIS. So if one action is connected to another, you have to look at the impacts of both actions and consider them together. And connected actions are actions that cannot or will not proceed unless other actions are taken previously or simultaneously. So basically we're talking about they're interdependent on each other, right? So that is, so you have to look at those. So the case on the relevant case is a Ninth Circuit case, Thomas versus Peterson, like those big logs there on the truck, right? So this is this was two actions, and the agency says, U.S. Forest Service says, we're building a logging road. So we have a road project. Then they say, we're having a timber harvesting and sales program. And we're going to harvest this timber and sell it. And the court says they're inextricably intertwined. And so you have to look at the cumulative impacts of both projects together in a single EIS instead of separate environmental assessments, instead of separate EAs. Okay, right? Because if you look at each one separately, it was determined that neither was going to have a significant impact on the environment. And notice what we're talking about. I mean, obviously, a road in the forest is going to have some impact on the environment, right? It's hard to imagine the road not having some impact, but that's significant impact, okay? So the road below the significant threshold. Timber harvesting and sales below the significant threshold. Why? In part because timber harvesting usually comes with reforestation as well, right? That's a mitigation, right? You're going to cut the tree down, but you plant another one, right? Right? Everybody's. I mean, of course, the Forest Service wants that. They want to be able to sell the timber in the future after the tree grows again, right? Okay. So together, though, they exceed the threshold of significance. So the court says they have to do this together. And the agency said, in our expertise, these are separate projects. But the court is not convinced, and they said, and the question is, are they being less deferential? Well, I think part of what's going on here is, again, it's that rule of reason, right? Just think about it for a moment. You wouldn't have the logging road if you weren't going to sell the timber, right? Harvest and sell the timber, right? You wouldn't need the logging road unless you're going to have logs, right? That seems pretty obvious. And you wouldn't be able to cut the trees and sell the timber unless you had the logging road. Right? Okay, so now what we're seeing is not that the agency's being less deferential, but just they're applying the rule of reason, and any reasonable person would believe that these are interdependent on each other. Right? Does everybody see what what's going on here on that? Okay, I'm gonna give you a chance to. Anybody? Okay, all right. I just want to make sure. All right. So one of the things that's out here is called the small handle problem, or the small federal handle problem. I mean, it's important. Sometimes I think it gets a lot of attention because it sounds like a cool thing. You can go around and say, yeah, small federal handle problem, whatever. But I think the gist here is that there are a lot of projects, a lot of actions that get taken that have both federal agency elements and non-federal elements. Right? And so let's assume you have a land development project that is primarily going to be regulated at the local level. There may be some state regulations that apply. Obviously, there's private sector action that's happening. It's a private developer is doing the development, but the developer needs a Section 404 permit under the Clean Water Act to fill in wetlands. Okay? And so the question is, does this now mean that the agency has to consider all of the impacts of the entire combination of federal and non-federal actions? And so you see, this is on one hand, all the impacts of the project, both federal and non-federal, are closely interrelated and may have significant cumulative impacts on the environment. But then on the other hand, the federal authority of the project may be quite limited in scope legally, and a broadly scoped EIS would essentially federalize a non-federal project. So they say, hey, we're now doing an EIS on this private land development project that's primarily local level. The judicial decisions are really very mixed on this. Okay, it's very mixed, and it in part depends on whether it depends on how the agency has decided to scope its EIS. So, so assume for a moment the U.S. Army Corps of Engineers is going to do an EIS, or actually they're going to start out doing an EA, right, on the Section 404 permit. Okay, they're going to issue a permit, Section 404 permit to fill the wetlands for this development project. And so they're going to do an EA, and they're going to ask, is the granting of this permit, that's the major federal action, is that going to have a significant impact on the environment or not, right? And if not, they'll issue a FONSI and so forth, right? If they do an EIS, will the EIS be limited solely to the filling of the wetlands part? Does everybody see that? Okay. What if they choose to say, hey, we're going to look at the entire development project, all of its impacts, whether we have any control over them or not, and look at, basically all the actions and all the impacts, okay? So a lot of it is going to turn then on what the agency decides to do. So and again, the cases are all over the map on this, but there are a number of cases where the courts defer to the agency, and usually the agency is looking at it narrowly. We're only going to assess the environmental impacts that are attributable solely to the federal government, the federal agency decision, right? Okay, does everybody see they do it narrow? And usually that means a FONSI, okay? So under what circumstances do you think the courts will defer to these agencies? Okay, so there's this deference going on. When does the deference actually show up in the courts? What do you think? Think about what we just talked about. What do you think is going to make the difference?
When the decision is turning on your special expertise.
Specialized expertise, and so how do we know that? What do we know? Where are we going to look for? I want to keep emphasizing that. The more that the agency lays out a well-reasoned, well-supported decision, and by supported meaning by evidence, by facts, by data, right? If it looks like the agency has given this a lot of thought, or another way to say is give it a hard look, right? And considered it and said, hey, the action is only the federal agency part, and the impacts can be considered, the impacts of the wetland permit can be considered separately from the impacts of the development project as a whole, and here's why, and here's the support for that. That's when the agency's going to get the most deference. Does everybody see that? Why? Why? Because the number one thing that the courts want the agencies to do is take their job seriously, is to apply the factors, the relevant factors, consider all the relevant evidence, and make a reasoned decision. Right? Does everybody see? Okay, so I'm going to keep emphasizing that pattern, because that's not always the right predictor of what the courts are going to do. Sometimes courts are more deferential, less deferential, but that's the best predictor. Okay, so the Sierra Club versus the U.S. is about some damage to visitor center and cabins and that kind of stuff in Yosemite National Park. Anybody been to Yosemite National Park? Oh my gosh.
Seen it on TV.
That's just wrong. That's so wrong. Okay, so we need to get like a travel fund for this. You guys need to get out and it's amazing. Oh my gosh, it's amazing. All right, so this is Yosemite Village, Yosemite Lodge, and so forth. Okay, lots and lots of people visit Yosemite. It's in the Sierra Nevada mountains. It's in basically northeastern California. It's beautiful, it's amazing, and it gets lots of visitors. And so they were going to have to do some reconstruction of the lodge facilities and other visitor facilities after a major flood. And the National Parks Service is wanting to do this really fast, okay? Because lots of people visit, and it takes a while to rebuild all this stuff, and so they want to get it up and going. And so they prepared an EA and then a FONSI, and basically what they said is all of these impacts were previously considered in the park's general management plan and in its concession services plan. So they want to rely on the previous plans. And so basically what they're saying is NEPA allows for what's called tiering. Okay, so tiers, right? Everybody read tiers of analysis, where you can have more broader decisions where you consider a wide range of impacts, and then when you get down to the smaller, narrower decisions, you don't have to do as much analysis at that point because you considered it originally as part of the broader thing, right? Does everybody see that's the gist of this? Well, and the regs allow for tiering. But the court says, while tiering is normally permissible, it's not permissible in this case because the earlier plans were too general. They were too broad. They did not contemplate this kind of project. And so there were no specific and detailed descriptions that would support NEPA analysis of this particular reconstruction project. Okay? So part of this is to introduce you to tiering. Tiering is normally permissible, but there comes a point at which the earlier broad decision is way too broad, and the analysis was way too broad, and it didn't really contemplate this future specific decision. The other thing is, part of what was going on is that the National Park Service did not really consider the no action alternative. Okay, so part of what was at issue here, in addition to the earlier plan being too broad, the earlier plan never contemplated what would happen if the lodge got washed away, or these visitor facilities got washed away by a flood, or destroyed. I mean, it didn't have to be a flood, but you just say they got destroyed, and we simply didn't replace them, right? You see, in that case, it's the no action alternative, right? And then so the no action alternative has to be considered in your NEPA analysis. Okay, no action alternative has to be considered in your NEPA analysis. Okay. Okay, I'm going to skip the next two slides. They're not that important. Okay, so the Marsh versus the United States is about a duty to prepare a supplemental EIS when new information about the impacts of a project come to light after the project is approved but before it's completed. And part of it is, point of the case is to introduce you to this requirement that a supplemental EIS does have to be prepared if there are new information, new impacts of the project. But it's also to emphasize this rule of reason again that the courts give a lot of attention to, which is what's the value of the new information on the still pending decision-making process. And so there are two questions. Is there still a major federal action left to occur? If so, then you ask, is the new information sufficient to show that the remaining action will affect the quality of the human environment in a significant manner or to a significant extent not already considered? And if that's yes as well, so yes to both, then a supplemental EIS will be prepared. And lo and behold, boom, right here, this is what I've been saying all class period, the court will defer to the agency's determinations if it appears that the agency has taken a hard look at the information and did not make an arbitrary or capricious decision when the information was not significant. So it's the same thing. Did they consider everything? Did they make a reasoned decision? Can the court see that? So the bottom line is when the agency doesn't take a hard look, it's bad for the agency. The courts are likely to say they failed to follow NEPA. So if they fail to prepare an EIS when the action likely has a significant impact on the human environment, the agency's going to lose. They fail to follow the mandatory process, the agency's going to lose. They fail to consider important impacts, alternatives, including the no action alternatives or evidence, the agency's going to lose. They engage in summary, conclusory, cursory analysis, the agency's going to lose. If the agency reaches patently unreasonable decisions or conclusions based on the standards and evidence that's in the record, right? The standards are there, and the evidence is there, and then the court's like, this doesn't make any sense in terms of what the agency actually decided, the agency's going to lose. So, coming back to your role with the U.S. Fish and Wildlife Service regarding prairie dogs and grasslands, okay? Once you get to the point of having one or more proposals for action to deal with that, you're going to have to go through the NEPA process, right? Right? I mean, you're like, I knew there was a point to this all along, right? We went through all this. Well, it's because to apply it, right? And so one of the things is you are going to want to advise your agency or in your role of sort of overseeing as assistant director to ensure that the agency does its EIS work. It takes a hard look, makes its decision with clear reference to the EIS. Or if there's not an EIS, to make sure that the FONSI is well supported. Okay? And again, you can choose to do environmentally harmful things, but you have to be transparent and thoughtful in doing so. Okay? So that's the gist. There is some discussion which we've sort of already talked about, so I'm going to give this sort of a short amount of attention, which is this NEPA force better decision making by federal agencies. And so I think there's some pretty good evidence that agency decisions after NEPA was adopted are much more environmentally conscious. They're much more aware of environmental impacts. That there are plenty of actions that do not get taken because the environmental impacts are brought to light. There's litigation over it, so sometimes that just ends up, deterring the agency or deterring the project proponents from moving forward. But one of the challenges is that NEPA analysis is very linear, right? You're at a given point in time, and you are trying to make some predictions about the future environmental impacts of a proposed action. And so that requires a fair amount of confidence in the agency's ability to predict what those actions are going to be, right? To model them, to gather data about what they could be, to know or predict accurately what they're going to be, and to assume that everything is going to play out in this linear fashion, where you make the decision, and then step 1 happens, and then step 2 happens, and then step 3 happens, and boom, there you go, right? And what we know from our discussion the other day about the episode 4 of the environmental law is that there's a lot of uncertainty, complex dynamics, instability, surprise disturbances. Basically we said unprecedented is the new normal, right? And so NEPA is not very well adapted to that. It doesn't really tell you what do you do if you don't have the foggiest idea what's going to happen, or you have 10 different competing models of what the future might look like, or if you make a decision based on a set of assumptions about the future, and then as you get implementing the decision, it turns out you're terribly wrong, or something goes awry. And go back to the example. You made an assessment, the U.S. Army Corps of Engineers, for example, made an assessment about the canals and levees that were designed to hold back floodwaters from New Orleans, right? And they were terribly wrong. And they simply did not consider several different factors that intersecting together meant that they had, what did we say? I forget, it was like 36 different breaches of those levees, which meant that all of New Orleans flooded after Katrina. It was actually after the storm hit, right? That was the problem. And it was because their assumptions were all based on a set of predictions that made sense at one time, but just did not contemplate that something like Katrina could happen. Okay, so so this is just about we've already seen about adaptive management and so forth. Okay, so on one hand, I think we might say there's more accountability to the public because of NEPA. There's more information, and the other thing I pointed out the other day is we actually now gather a lot more information. And we have better models about what the impacts of what we do are because of NEPA, because it's legally demanded. That creates, creates a market for it, right? Right? I mean, so if you think about this, agencies need this. So what does this mean? It means there are a bunch of scientists running around U of L and other places doing these kinds of studies because there's a demand for that kind of knowledge or that kind of modeling or that kind of assessment process, right? I mean, so that's part of what the benefits of NEPA have been. Whether it's actually done enough to make environmentally better decisions, that's not clear. All right. So that's NEPA. At the end of class, I want you to take one of these, which is this, and I just ignore the fall 2017. The standards haven't changed since I taught environmental law 2 years ago, and this is a PDF. I wanted to go in and try to change it. But these are federal land management legal standards. So we're going to talk about them. Okay, so we're going to talk about them on Monday. But what I want to do now is turn to the fact that some way that you as a U.S. Fish and Wildlife Service official, you as an employee of the U.S. Department of Interior might be able to get a handle on grassland conservation and prairie dog conservation is to focus on federal lands, okay? On lands owned by the federal government, because whether it's your agency or not, at least it's the federal government that controls what happens on those lands. And we've previously talked about the various different kinds of federal lands that are out there. There are national parks, right? There are national forests. There are national fish and wildlife refuges, right? Or national wildlife refuges. There are what are called BLM lands, Bureau of Land Management lands. These are sort of general purpose lands and so forth. There's something called the national grasslands, okay, so that's a particular designation. And of course there's national parks. Each of these categories has been established by Congress pursuant to what's called an Organic Act. Okay? So there is what's called an Organic Act, and it's called organic because it means these are the big, broad principles for designating and managing certain lands as for these certain purposes. So national parks are managed a particular way by the National Park Service. National wildlife refuges are managed another way by the U.S. Fish and Wildlife Service, and so on and so forth. You have the national forest, and so forth. So you have these organic acts. Then, for some of the lands, you have additional federal statutes that establish land management procedures and standards, that cut across all, whether it's national parks or all forests or so on and so forth. And then you have statutes designating particular units. So there actually back in the 40s was when the Everglades National Park was established, right? And there is a specific statute establishing the Everglades National Park, and the standards for managing the Everglades National Park are different and distinct from the standards for managing Yosemite, the standards for managing Mammoth Cave National Park, et cetera, et cetera. Okay, so these are what are called establishment acts, and these are when Congress has established a particular unit. So there's the Medicine Bow National Forest in Wyoming, okay? And that is a particular forest, and there's going to be a specific establishment act for the Medicine Bow National Forest. So what does that mean? It means the agencies that are responsible for managing a particular unit of federal land are going to have a series of federal statutes that direct them as far as the standards and procedures for managing those federal lands. Okay? And so we're going to go through and talk about those. We're going to start, though, before we're going to start at the end of class now. We've got 5 more minutes, and then we're going to pick this up because I want you to then think about it. But I want you to think a little bit about something we started talking about earlier in the semester, which is cultural competence. Okay? So cultural competence is about considering a range of diverse perspectives, right, on environmental issues, legal issues, and so forth. So part of thinking about how an agency might go about implementing these necessitates thinking about how different groups and populations, particularly those groups and populations that are maybe less powerful or more on the margins or maybe more in the minority or something like that, how they might have different viewpoints about federal lands than the agency might, or than sort of the mainstream population might. Okay? So let's think about this for a moment. Native American tribes, Indian tribes, how do you think they view federal lands? What do you think is the Native American? And I don't want to suggest that there's a perspective, but I think we can find some commonalities that you find with many Native American tribes in sort of ways that they might look at federal lands. Start there. So I think one of the things that's going on here is you kind of think outside, right, of your experience, outside of your particular perspective. Yeah.
I have no idea. I'm just going to guess. Maybe they just really don't care about them.
Maybe they don't care.
They feel like that used to be their land, maybe, or our lands aren't protected. So why do I care about that one?
Okay, so let's start with the first part of that, which is, okay, where did these lands come from? Well, originally, they were lands possessed and controlled by Native American tribes, right? Right. I mean, so that is significant. The tribe no longer controls those lands. So if, for example, the Grand Canyon, there are parts of it that are considered sacred to certain tribes, right? That's all. It's all controlled and run by some federal agency with a bunch of other priorities, right? Because so as you see, that's one way to sort of think about it. All right. It's possible then that might lead to a certain amount of diffidence about this, right? You're just, well, who, I mean, this isn't ours, and we're not on the same page as these agencies. But I think there might be the opposite. Yeah.
I was going to say that, and again, I don't know enough, but generalizing, usually they believe that the land doesn't actually belong to anybody, it belongs to everybody. And so using federal land is actually a public land at that point, so it's at least not being held by private landowners.
So one thing is the public nature of it becomes closer. It's not the same, but it becomes closer to this idea that this is a community resource or a shared resource. Okay, the other thing to think about, because we're just almost out of time, is what about the extent to which the federal management serves conservation purposes? Okay, so now there is not going to be privatized, it's not going to be developed, it's not going to be, right, so for example, yes, there are visitors to, people coming and tromping around and taking pictures and selfies and whatnot, right, but you're protecting these ecological resources that the tribes consider valuable. So, for example, there's enormous controversy over Bears Ears National Monument in Utah, right? The scope of it and how it was done and so on and so forth. And so it was very broadly done in the Obama administration, and then it was vastly shrunk back in the Trump administration. Well, one of the things that has, that's part of that process is that a lot of the tribes in Utah pushed back or joined in the lawsuits against the shrinking of Bears Ears National Monument because they wanted those lands to be protected. They viewed them as sacred, they viewed them as important, and so they viewed the National Monument designation as helping to serve their goals and their interests, okay? So part of what I'm trying to get you to do is sort of think about those different perspectives. So one of the things we're going to talk about, don't let me forget, but at the beginning of class is, what about lower income groups and lower income communities? What about communities of color, people who, how do they sort of think about national parks and public lands and other kinds of things? So we're going to start talking about that at the beginning of class, and then we're going to turn and look at the very specific kinds of standards that govern. But be sure to take a look at, I'm going to also post this on Blackboard, but I'm going to put it right here and take a look at that before class on Monday.